everyone. Thank you for the opportunity to present my paper. I do not really come from the background of technology or big data. I'm more concerned with issues of human rights, exclusion of disadvantaged groups from society, from political participation. And in my paper, entitled Big Data and the Right to Have Rights, I focus on a different perspective, I think, of the connection between big data and human rights. I think my impression is that most academic and public discussions about big data and human rights currently focus on how the inclusion of one's personal information in big data systems might undermine that person's basic human rights, such as, for example, the right to privacy, the right to freedom of expression. There are also concerns about cybercrime and other threats that might that threaten people who are included in big databases that are used by both private actors, corporations, and public actors. And by contrast, my paper seeks to examine the negative implications that the big data revolution might have for those people who are left outside, who are not caught in the net of big data. That means people who do not leave digital traces that later become part of big data, or do not leave as many digital traces as other people. Now, more specifically, my paper explores the implications of exclusion from big data in the public sector. I argue that in view of the increasing reliance of government authorities in many states on big data analysis to inform their practices, their decisions, their legislative and regulative acts, big data outsiders nowadays may miss important opportunities to affect public policy. These people may be deprived of the basic right to political participation. Now, the main group that suffers from this exclusion are people from socioeconomically disadvantaged groups, mainly people with lower income and less education, who produce less digital data in general and less so-called policy-oriented, what I call policy-oriented digital data in particular. That is, big data that can be used for purposes of big data analysis by government authorities. Of course, compared to wealthier and more educated people. Now, before I discuss this problem or try to theorize it, I want to give some examples of this so-called exclusion from policy-oriented big data. Now, I take this example from the United States, from two sectors, one that are currently relatively data-rich sectors, that is the healthcare sector and the urban planning sector in the United States. And I would like to mention several big data projects that are pursued by, or are intended to be pursued in the near future by federal and local authorities, and to explain why or how these projects are likely to disengage socioeconomically disadvantaged groups. Okay. In the paper, I mentioned more examples. Now we'll just mention two examples from each sector. So in the healthcare sector, one example is the Epidemic Prediction Initiative of the Centers for Disease Control and Prevention, the CDC, which is a governmental body in the United States. This initiative was launched in 2013. And it seeks to predict the outbreak and spread of infectious diseases by conducting real-time analysis of internet search terms related to these diseases. Currently, it is implemented on influenza, but in the future, it is also planned to be applied to other infectious diseases such as the dengue fever and the Ebola. Probably you can see all the details in the Center for Disease Control and Prevention website. Maybe some of you are familiar with the Google Flu Trends project. So this is a similar one, but initiated and managed by the government. So the point is that in view of the poorer, in view of the fact that poorer and less educated people do not use the internet for medical purposes, for searches for medical information, for uploading or downloading medical documents, etc., as much as wealthier people, the epidemic prediction system is likely to be less effective with respect to poorer areas, towns or regions in the United States that populate poorer people will probably be not as effectively monitored by the CDC as other wealthier areas where people are more active in internet searches, in using online medical services, etc. And as a result, the population in these areas may not benefit from measures taken by healthcare officials to prevent and mitigate infectious diseases, which are planned to be taken on the basis of, in this case, on the basis of the spread of diseases as soon as the authorities are informed about the epidemics. Now, another project, another interesting project is the Big Data to Knowledge, BD2K initiative, which was launched in 2014 by the National Institute of Health, the NIH, in order to promote big data-based biomedical research in the US. This project focuses on building large-scale biomedical data sets and developing relevant analysis methods. And the main source of data for this project, for the BDTK databases, are electronic health records, EHRs, which are collected from hospitals and from medical clinics and which contain anonymized information about patients' blood test results, genetic information, diagnosis, medications, etc. Now, as you probably, as most of you probably know, there are millions of Americans today that cannot afford the costs of attending hospitals and medical clinics, and therefore their medical data do not appear in electronic health records. In 2016, 28 million people in America were not covered by any medical insurance, and this is a much better situation compared to, for example, 2010, before the Obamacare. And the situation may get worse again because we know that the current administration is trying to change the Obamacare. So there are tens of millions of people who are not covered by any medical insurance, and those people are, of course, not represented in electronic health records. That is their diseases, their unique medical needs, which are, and there are many indications that medical needs are in many cases divided by groups of population. For example, by ethnic origin, there are for example, diabetes or asthma are sometimes more common among poorer populations, among certain ethnic groups, etc. So those big data to knowledge data sets may not represent the problems, the habits, the patterns of certain groups of population. And even if we take populations that do have medical insurance and do attend medical clinics and hospitals, it is important to mention that usually bigger medical centers in bigger, wealthier areas have better technologies, more advanced uses of electronic health records and other digital data, whereas more peripheral, smaller medical centers, which are located usually in poorer areas, do not have as much data that can be transferred to the central authorities, to the National Institute of Health. So now moving from the healthcare sector, I'm just checking how much time I have. Okay, moving from the healthcare sector to urban planning. I will also give two examples. You probably know that many cities in the United States and around the world today are attempting to become so-called smart cities that rely on big data analysis in order to use their infrastructure and resources more efficiently. And many urban big data projects extract information from crowdsourced mobile applications such as Waze, which tracks motor activity, and another example is Strava Metro, which tracks bicycle activity. And the data that is collected from these sources is used by city municipalities to improve both the day-to-day operation of city infrastructure, and also the long-term planning of urban services, in that case, urban transportation. But the problem is that these kind of smartphone applications, these are just a few examples. There are many more. If you heard about the street bumps, the 311 applications, other smartphone applications that are used by municipal authorities to collect data and improve their services. They are less commonly used by disadvantaged populations, poor or less educated populations. Again, not only because they own fewer smartphones, but also due to various socio-psychological barriers to the use of advanced technology for such purposes. Now, as a result, poor neighborhoods may not equally benefit from the services and policies that municipal authorities develop on the basis of the data that these applications generate. And one more example, just to conclude this part, there's also an increasing number of smart city projects that that currently use outdoor sensors or plan to use outdoor sensors that the local authorities install in public places. Now, basically this top-down method of data collection does not require city residents to own or use digital technologies, but it may nevertheless have exclusionary effects on poorer population due to the well-known tendency of public officials to award higher priority to the needs of more powerful groups among their constituencies, among their urban population, and this may lead local officials to place more digital sensors in wealthier neighborhoods than in less prosperous neighborhoods within their towns. And one project that I analyzed that demonstrates this tendency is it's called the Array of Things, which is currently planned to be implemented in the coming years in Chicago. And under this project, the city of Chicago plans to install on traffic light poles about 500 sensors that will measure air quality, pedestrian and vehicular traffic, and other factors. And the map that they already published that shows the location of the first 50 nodes that are planned to be installed next year show that already the first 50 nodes are located in the most prosperous, the richer neighborhoods of Chicago, whereas poor neighborhoods are not going to enjoy the project, at least in the first phases, which can show us something about where big data is collected, what does it represent, and then again, poorer neighborhoods are likely to be less represented, to receive less services, and there are many other projects that are currently planned in many other cities in the US and other places. And so I do not have time to talk about other sectors, but we can see similar examples, for example, in the area of response to disasters, to environmental disasters, also in education, I believe. I did not explore, but I believe that big data in education does not represent all part of the population equally. And there are also other relevant sectors that can provide examples. And so, I'm not sure, yeah, okay. So what I will do, I want to speak a little bit, 5 minutes, to try to conceptualize this problem using Hannah Arendt's political theory. And in the paper, I also offer a doctrinal analysis of how these problems can be mitigated or addressed through United States constitutional law, for example, whether or not the Equal Protection Clause, the Privileges and Immunities Clause of the United States Constitution can address these problems, or whether we need a new legislation or new regulation. But I think since we're not focusing on the United States now, but more on the theoretical problem, just using the US as an example, so this part is not necessary. I want to speak a little bit about Hannah Arendt's theory, especially about her concept of the right to have rights. This is a concept that she develops in her books, The Origins of Totalitarianism from 1951. When she speaks about the right to have rights, Hannah Arendt, the political theorist, German-American political theorist Hannah Arendt, refers to the right of every person to belong to a political community in which that person is recognized as an equal partner to shaping public affairs, a community where her actions and opinions are taken seriously and can make a difference. Now, Arendt emphasizes the basic right of every person to have what she calls, I'm citing, a place in the world which makes opinions significant and actions effective. And she emphasizes that in that book that for her, the way she sees it, the right to action is no less important than the right to be left alone, and that the right to opinion is no less important than the right to think whatever one pleases. And when we think about those ideas in the context of big data, I think that the idea of the right to have rights can help us move away from the liberal academic and public discourse that currently focuses almost exclusively on the right to be excluded from big data, not to be under constant surveillance of corporations or of government authorities, and also think also to recognize the importance for some people of the right to be included in big data, which may be essential for participation, for meaningful participation in public life, important for having the chance to somehow influence public policies, to have the public authorities take into account your own or your group or your social groups' habits, preferences, interests, etc. Now, of course, Arendt developed her theory in an entirely different context, in the context of stateless persons in Europe, between and after the world wars, and she was concerned with the plight of refugees who had no citizenship whatsoever and could not realize their human rights. But I think that in a way, if we think about citizenship today, I think that what matters is not only having citizenship, but also in today's, digitized, globalized world, is not only having citizenship in order to realize your rights, but also having access and ability to participate in digital activity, in big data analysis. And I think this is a direction that is developing and will be more dominant in the coming years. So although I'm not comparing the plight of stateless persons to the plight of people who are left outside big data, I think Arendt's concept can help us think about the importance of having an opportunity to participate in public life, to have your actions and activities relevant and influencing. And that this is a very basic right that we must not play down. And so I have like 1 more minute, okay? I'll try to think how to conclude. Okay. I will not refer to Hannah Arendt also has an interesting analogy of what she called the citizenship as a mask, how people in democracy are, by virtue of their being equal before the law, are all can all be equal, and how the law or the authorities should disregard all their personal, ethnic, racial, religious characteristics. And I think that in the same way we can think about what big data could do, how behind the veil of anonymized data, people could potentially have equal opportunities to affect public life more than they have today. But I'm afraid that what happens is if we do not attempt, if we do not notice, do not pay attention to those issues, then this equalizing potential may not be realized. And what might happen is that big data might, I would say, reinforce existing inequalities rather than fulfill its equalizing potential. And I think, one last sentence, that one of the problematic aspects of this unequal effects is that many people think or try to convince others that big data is objective, is essentially true, that it is inclusive, that it has no biases. And I think this is why it is especially important to be aware of the possible gap between the potential of big data to serve as an equalizing tool and the real effect that it might have if people are excluded from the very databases that are used as a platform for public policy making. That's it.
Thanks, Michal. Great. Great, so our next speaker is Doaa Elyounes. Doaa is a doctoral student at Harvard Law School and a fellow at the Berkman Klein Center for Internet and Society at Harvard Law School. Doaa researches the effect of artificial intelligence algorithms on the criminal justice system and the legal framework that is suitable to govern this new space. Doaa completed her LLM at Harvard Law School, as well as an LLB and LLM in Law and Technology in the University of Haifa, Israel. After law school, Doaa worked at the Supreme Court of Israel as a law clerk and at the Israeli Ministry of Justice as an advisor to the Director General of the ministry. And Doaa will be speaking to us about bail or jail, judicial versus algorithmic decision-making in the pretrial system.
Good afternoon, everybody. I'm really excited to be here as a former student for the first time from this side of the room. It feels different. So to warm up and to see if you're all awake after lunch, let's start with a small exercise and show me, just by a show of hands, even if it was once, whom jaywalked, whom he crossed the street, even if the light was not green. Now, I'm going to assume, without seeing, that all of you did it once. And now the rhetorical question I will try to explore with you today is whether you want to be judged by a human being judge or an algorithm. So I will just say that I picked explicitly such a small crime because we are all a family, but maybe it's good to keep some stuff for a more private setting. Now, we have all heard about the sophisticated algorithms that are threatening to take over the criminal justice system. They're supposed to be smarter than us, less biased. They will never be tired or in a bad mood because they fought with their partners the night before. But should we embrace these algorithms? How different they are from the existing ones, and what consideration judges and policymakers need to take into account while thinking about their adaptations. These are the questions I will try to answer in my presentation, claiming that the pretrial stage is a good place to start thinking about the implementation of risk assessment tools that are based on modern AI techniques. The implementation will not be easy. It requires policy changes as well as increased transparency and collaboration between different disciplines. Now, to unpack this question, let me start by explaining the development of the pretrial system in the US. It's no surprise that the United States is a world leader in the numbers of pretrial detainees. On any given day, almost 500,000 detainees were held in jail, awaiting trial. The pretrial stage is supposed to be a very short stage that starts when the judge determines that there is a probable cause to support a criminal charge, and it ends when the case is adjudicated or dismissed. Legally, the defendant is perceived innocent, and the government has the burden of proof to the guilt of the defendants. The judges is only allowed to look at two very simple and narrow factors: failure to appear, whether the person will come to the actual trial or not, and whether the defendant will commit another crime when waiting in jail. The person is arrested. The judges need to determine the conditions in which the person will be released. When preventive detention is supposed to be like the last resort, and it's saved only to the riskiest of defendants. In order to distinguish between high, medium, and low-risk defendants, judges started to use different versions of risk assessment tools more than 50 years ago. Predictive algorithms rationalize the decision-making process in a more efficient way than a human being. Actuarial tools have shown greater predictions over clinical predictions, and they can help eliminating some of the discretionary power of judges. Judges, especially elected judges, they bear responsibility for crimes that go unpunished. So they tend to be more strict and detain more defendants than even if they are not the riskiest ones. Now, despite the benefits, many controversies surrounding these tools, and the first major one is about the factors to be included. Although criminal history proved to be the best predictor for failure to appear in pretrial, but some scholars are opposing to the use of criminal history because it's a proxy for race. Others oppose to the use of sociodemographic factors because the individual bear very little responsibility for them. The second criticism is about the ability to come up with conclusions about the individual based on his or her group prediction. What machine learning has to do with all these? So all the existing tools that are being used today are based on statistical regression analysis methods. The difference between regression analysis and machine learning is the volume of the data and the human involvement in building the models. Machine learning algorithms are capable of learning from trillions of observations. They make predictions and learn simultaneously. However, statistical models are generally applied for smaller data with less attributes. So when we talk about the implementation of machine learning techniques, the biggest fear is usually explainability. The fact that an algorithm will come up with a conclusion that will affect detention or release seems not plausible from the legal perspective. We tend to think that human decision makers are themselves interpretable because they can explain their action. But precisely what notions of interpretability do these explanations satisfy? Let me illustrate while using an example. If there is a big data set of movie reviews, for us it's easy to tell which one is a positive or negative based on our life experiences. If we want a computer to do these tasks, there are two options. The first one is to label, to identify the words that are associated with positive reviews and the words that are associated with negative reviews, and to teach that to the computer and let it perform. If we do that, we have a 60% rate of accuracy. Another way to do this is by having a human being label the reviews as positive or negative, but then let the computer to figure out on its own what makes this review as positive or negative. Turns out that if we use this method, we have 80% rate of accuracy, because it's very hard for us to introspect and to explain how do we do these tasks of interpretability. I am not claiming that we should give up about interpretability, definitely not in the criminal justice. However, I think that pretrial is unique. As I mentioned before, the judges are limited to only two factors, failure to appear and public safety. And that's different from, for example, from the sentencing stage, in which judges consider a longer and more complicated set of factors, such as failure to long-term recidivism, which is harder to predict. We should also distinct between the kinds of factors that we are including in the tools and the weight that we are giving to each factor. And even in the traditional regression analysis tools, as I said, the debate is more about the factors to be included and not about the weight of them. The question should be, what is the automated task that the algorithm is performing, and how significant this obscurity for a fair due process? Now, to all that, we should add the fact that pretrial hearings are usually short and fast, and defendants don't have a lot of room to raise substantive claims about the algorithm. One study that implements such a tool, a sophisticated tool, on pretrial is the study conducted by Kleinberg and his colleagues. Only based on age, criminal history, and current offense, they managed to build an algorithm that predict failure on pretrial. And like the movie reviews example, no calculations were involved in the teaching process. The results of the study are quite promising. They show that using machine learning techniques, we can increase crime rate up to 24%. We also can increase jailing rate and racial disparities. They are aware of the fact that judges are considering more than 3 factors when they reach their decisions, but they conclude that judges are distracted by noise when they are exposed to more factors than needed. Now, it's important to remember that this is the first attempt to apply such technology in the pretrial, and it's still an open question if we are ready to give up about judges. In my paper, I assessed 4 existing risk assessment tools. Now, bear with me just for a moment. I will just address the tools now and then explain why did I use them. The tools I looked at is the federal tool that was built by the US Administrative Office of the Court in 2003. The public safety assessment developed by the Laura and John Arnold Foundation, a nonprofit foundation in 2013. It's a commonly used tool, and it's been adopted by more than 38 jurisdictions. The third one is the Virginia tool. It's a relatively old tool from 2003, well-researched and also adopted by other jurisdictions. And the last one is the Colorado tool, which is good because it explains exactly why each factor in the tool is chosen. Now, I mentioned these tools because I want to now address comparison between the tool that I made. I compared between them on a higher level and assessed the impact of AI on these tools. And the first factor for comparison I want to talk about is the items included in each tool and, the item included in each tool. So as you can see, all the tools include between 8 to 12 factors that consist of a combination between current offense, criminal history, community ties, and some socio-demographic factors. Applying machine learning will allow policymakers to explore more factors because of the ease in analyzing greater amount of data. I want to highlight the importance of unpacking each factors and providing multiple options for the defendant. For example, employment. In the federal tools, the options are employed or non-employed. And in Virginia, being a student, a full-time student, retired, or a primary caregiver considered as some sort of employment and doesn't give defendants negative points that will be added to their risk score. The same for residence. While in the federal tool, you have to own a home or be in the process of buying it, other tools consider rent as well. The second factor for comparison I want to talk about is the source of the data, interview-based or solely databases. All the tools except the Arnold Foundation tools are built on a combination between these dynamic and static factors. There is a debate in the literature that I touched a bit upon before about which set of factors is a better predictor. Machine learning, I think, will help eliminating some of the discretionary power of court officers that are conducting the interviews. For example, in Colorado, 8 out of the 12 factors are interview-based, and the officers are allowed to include a longer interview with the defendants and include their impression. In item 4 of the tool, the defendant is being asked, do you believe that you currently have or have ever had a problem with your use of alcohol? And the term problem is not defined, and the leeway is very narrow. The answer could be only yes or no. From the source of the data to the quality of the data. Risk assessment hinge on reliable methods of gathering high-quality data. However, criminal justice data is notoriously poor. The Arnold Foundation tool is the tool that was developed on the biggest data set, based on the biggest database. 1.5 million cases that were drawn from more than 300 US jurisdictions. But of course, there was no consistency in the type of data that was collected in each jurisdiction. And to mathematically adjust this gap is not an easy task. There is also the Ratchet Effect. If historically only one group of minorities were arrested and convicted for certain type of crimes, then the dataset will include large information about these minorities and very small information about the others. And that might skew the outcome of the algorithm. Now, one type of data that should be eliminated from the tools, but despite the fact that it's still being used, is arrest data. And given the ratchet effect that I just explained, arrest data will have very negative impact. How much time? Okay. Another factor I will mention is periodical validations. Most states end up adopting a tool that was developed by somebody else. But validation study is a very important task. Sometimes differences between jurisdictions justify developing different tools. For example, the federal courts are the only courts that analyze immigration cases. So immigration status might be a legitimate factor to consider if this is the issue at stake. Now, validation studies are also important in order to make sure that technology, the tools are keeping up with social and technological developments. In the past, having a landline phone in the defendant's residence was a very good predictor. But given the reliable on cell phone technology, probably it's not the case anymore. Separating between separate prediction for flight risk and public safety. Most tools, except the Arnold Foundation one, provide one score both for public safety and flight risk. It's important to separate them because the government burden of proof is higher for the danger that is based on risk, on danger. Also, separating between the two will allow us to align between the conditions that we impose on defendants to the actual need. If one might flee, maybe we can take his or her passport, but we don't need to keep them in jail until the end of the process. The last factor I want to mention is the distinction between types of flight risks and categories of crime. It's important to know whether one might flee because they can't come to court because they don't have the money to do so, or because they need to work, because otherwise they'll be fired and will not be able to support their families, or because they're planning to escape the country. And the same for public safety. We want to know if one might commit a homicide while awaiting trial or stealing a piece of bread from a bakery. Failures, false negatives are treated as way more costly than false negatives. But I think that machine learning has a great potential to help us understand exactly what does the risk score actually mean. The only tool that is doing that right now in a small scale is the Arnold Foundation tool, which highlight flag defendants that are on a high risk to commit a violent crime. To conclude, pretrial is the front door of the criminal justice system. And any decision that will be taken will have a great impact on the trial itself and on the defendant's future. Applying machine learning technology on such a sensitive area requires careful consideration. First of all, we need to assure at least transparency to the factors themselves that are going into the tools, if not to the weight that we are giving to each factors. And also we need to enhance collaboration between different disciplines. Computer scientists and engineers need to understand that policy needs to be embodied as part of the design of the algorithms. And if we lawyers and policymakers want to benefit from these technologies, we should first of all overcome our hostility toward quantification of such algorithms. Thank you.
Great, thank you very much. So our final speaker for this session is Yoni Carmel. Yoni is a PhD student at the Haifa Center for Law and Technology, writing his dissertation under the supervision of Professor Nivel Koren and Professor Michal from the Institute of Research and Development of Alternatives in Education. Carmel investigates the interactions between law, education, and technology in the digital age from legal and pedagogical perspectives. And no less important, in addition to practicing and studying law, Yoni is also a former high school teacher in the Teach for Israel program. Yoni will present an article we co-authored named Reshaping Ability Grouping Through Big Data.
First of all, thank you, Tammy. And this is a good opportunity to thank you for engaging in this project and for agreeing to writing the paper with me. Just a sec. And thank you all for sticking around and not leaving after lunch. Right. So we'll be talking about big data, education, and discrimination, and one case study which is, I think, interesting. So one of the greatest challenges of comprehensive education, it lies in the wide variation of students' innate abilities. Now, faced with this challenge, good? No. Many education systems, they divide students into groups, and we all know that, according to their academic abilities. Now, this is the way they decrease heterogeneity in the classroom, and this practice is commonly known as ability grouping, and if you live in the UK, it could be called tracking, or in Germany, it will be stratification. It depends where you live, of course. And despite being one of the most controversial issues in American education for almost a century, in the past decade, the practice of ability grouping has thrived. Okay, we see a big increase in the use of ability grouping in classes. And educators have been fiercely debating the effectiveness of ability grouping for the last 3 decades or so, But overshading this debate is a concern that ability grouping creates or maybe worsens educational inequality between students. Overall, most writers on ability grouping, they have concluded that grouping students by their academic ability, it contributes to widening the achievement gap between low and high classes. And these findings are all the more troubling since considerable research, it supports the assertion that racial minorities and students from poor background are severely overrepresented in lower tracks, whereas students from privileged background tend to be assigned to higher proportions to higher tracks. Now, you can say that long social inequality is surely to blame for inequality in academic abilities, but this is also the result of the implicit biases that pervade educational decision-making. Well-documented evidence shows that teachers tend to underestimate the actual academic abilities of racial minorities, of children from poor background, and girls. And these biases, they cause the stratification of disadvantaged children and students into lower tracks, where in those lower tracks they receive inferior education and a limited range of opportunities. Now, our question in this paper was, can technology avoid these biases, these human biases, and can it afford a more objective and a more bias-free method for grouping or for sorting students? We, of course, we focus on the US, but I think the discussion is relevant for every educational system. So in recent years, educators have witnessed an overwhelming interest in using data to inform decision-making. This practice is called educational data-driven decision-making, and in this practice, educators are supposed to examine data, to make sense of it, and then to translate their understanding of the data into action. And in parallel to education becoming more data-driven, today's core educational activities, they increasingly rely on technologies, such as learning management system, digital textbooks, educational application, mobile devices, social media, and other applications that can be used inside the classroom. Sorry. And the use of this technology, we're talking about big data, of course, right? So the use of these technologies, it creates an enormous amount of granular learning-related data that simply cannot be processed by using, thank you, by using conventional applications.
We're doing all the hard work, so I'm just...
This is collaboration. So to make sense of all those quantity and diversity of data, developers have been increasingly using educational data mining. And educational data mining, it takes those seemingly unrelated points of data and it finds unexpected patterns and correlations within them. And grouping students is quoted and is discussed as one of the most discussed uses of educational data mining. Now, our question is, will educational data mining mitigate or exacerbate biases in ability grouping decision? Overall, proponents of data-driven decision-making, they believe that this type of decision-making process is more accurate and more bias-free than traditional decision-making. However, the use of big data, it does create a new set, and a unique set of challenges in terms of educational equality between students. First of all, big data can perpetuate past inequalities. Algorithms, they make their prediction based on past data. And for example, if successful participants in honors class were historically white and privileged, then the algorithm may try to locate candidates who are similar to successful past graduates. And an obvious expression of how using certain inputs for the algorithm to process will eventually result in discriminatory outputs. It involves allowing suspicious, this is obvious, of course, is allowing suspicious attributes such as race, gender, ethnicity to feature in the database, the data sets. And even when algorithms are not supplied with suspicious attributes, there are often other attributes that correlate with suspicious classification. For example, due to residential segregation, for example, the seemingly neutral attribute of a zip code, it can denote race. In other cases, data that is relevant for educational decision-making can also correlate with suspicious classifications, such as data concerning discipline or data concerning attendance. And often, members of protected classes are disadvantaged because the factors that better account and better describe them are not well represented in the data set. Just to take an obvious example, there are some grouping models that tend to assign a considerable weight to the time a student spends doing homework on a learning management system, on Moodle, for example. Now, this data doesn't necessarily communicate very much about the student's academic capability, and on the other hand, it disadvantages students from poor background who tend to use computers much less than their privileged peers. And also, anyhow, relying on information obtained from technological application, it can have discriminatory effect due to the gap in technological proficiency and online access. And despite the fact that algorithms, they work, quote unquote, independently, they are ultimately designed by humans. Therefore, biases, they may appear at every stage of the process. For example, an algorithm can be programmed, an algorithm that is used to assign students to a course, it can be programmed to predict which students are most likely to succeed in the course. On the other hand, it can also be programmed to predict which students will likely to benefit the most from the course. Now, the distinction is very important, and we think that programmers and developers, that they should take and make those value-laden decisions when they program the algorithms. You excuse me again? And another challenge, I've been speaking so much all day, so I ran out of voice. And another challenge, it concerns the opacity of algorithms. You know, and we've been talking about it for a long time, that the complexity of algorithms may often hinder any attempt to unpack the rational. And sometimes even the technical processes that are involved in the algorithmic systems are treated as confidential or proprietary. Therefore, the affected individual has limited ability to learn what are the reasons for a certain decision, and thus he has limited ability to challenge these decisions. So we now see that also big data-driven decision-making is also subject to biases. But the question is, why are these problems especially troubling when we're talking about ability grouping? We've been talking about discrimination in big data in many other fields. But in other fields, it is possible to examine the prediction after the fact. If, for example, an algorithm points to a certain potential suspect, a police officer, it wouldn't be that convenient, but a police officer can search the individual, and this way to disprove the algorithmic prediction. But when we're talking about ability grouping, the prediction that leads to the assignment of the student to a certain track, it does more than just indicating the ability of the student. It constitutes its ability. It constitutes it by affecting the quality of education that he will receive, its peer effect, teachers' expectations, his self-expectation, and also the learning opportunities that will be blocked because he's been assigned to a lower track. Therefore, because the prediction itself has influence over the student's ability, testing the validity of the algorithmic prediction by examining the final achievement would be unhelpful. So after we understand the promises and those pitfalls of big data for ability grouping, I would like to talk about how law can be used to promote more equality. So far, the segregatory effects of traditional ability grouping, they have been challenged in American courts several times, based mainly on the Equal Protection Clause of the 14th Amendment, and to a lesser extent on Title VI of the 1964 Civil Rights Act. And though successful in some cases, Overall, existing equal protection jurisprudence has been largely ineffective in safeguarding equality for disadvantaged groups, because the difficulty to prove intentional discrimination and the continued disagreement as for the desirability of ability grouping, they made courts reluctant to strike down ability grouping policies. We claim that in the case of data-driven ability grouping, the existing doctrines are even less likely to be effective in challenging the unequal effects of ability grouping. First of all, algorithmic decision-making, this is very clear, they're perceived as more scientific and more objective and more accurate, and therefore courts are even more likely to defer to the grouping decisions made by algorithms. This is one reason. In addition, overall, educational data mining is very successful in masking intentional discrimination behind layers upon layers of mirrors and proxies. And while data mining certainly introduces novel ways to conceal intentional discrimination, unintentional discrimination is much more likely to appear. And so far, courts have refrained from seriously considering the possibility that even good faith efforts at grouping could be biased. And therefore, without proof of intent, it will be impossible to properly scrutinize the algorithm, notwithstanding the fact that the unintentional consequences could be extremely detrimental in terms of equality between students. I'll have another zip. And I have time? Oh, okay. I'm the last one before our keynote, so I'll take my time. Educational data mining also creates a unique problem regarding the use of the rational basis test. According to this test, in order to uphold a classification, it must be merely shown that it demonstrates reasonable relation to a legitimate governmental interest. But data mining attempts to locate statistical relationships and correlations between attributes in a data set. Now, these statistical correlations are always rational in the sense that they are statistically valid. Therefore, any finding whatsoever that an algorithm makes could be considered as rational and would pass the legal test. Now, our argument, it aims to show that challenging ability grouping in courts wouldn't be a promising route for promoting equality. Instead, we argue that law can be more useful and more effective in preventing those human and implicit and all those biases that that can be perpetuated by educational decision making if it is involved in the design and the application of ability grouping algorithms. Why is legal intervention required? All those computer scientists will ask. It's because legal intervention is required for two reasons. First of all, designing equality-sensitive algorithms, it entails normative determinations that, let's face it, that legal doctrine and scholarships are better equipped to do. Law will determine which classes are protected, what will be considered as affirmative action. And secondly, legal regulation also ensures universal implementation. Therefore, it will ensure that districts, school districts, or in Israel, the Ministry of Education, will vet and implement bias-reducing systems. Now, we don't claim to offer here any comprehensive solution. We just wish to describe how such future solution may look like and offer some insights into the ways technological and legal solution ought to be integrated to achieve the ultimate goal. To prevent suspicious classification, some scientists suggest to remove discriminatory attributes such as race, gender, and ethnicity from the data sets. Now, this task of removing attributes that correlate suspicious classification, it can prove to be quite a challenging task because sometimes, maybe often even, the correlation is created through the combination of multiple types of data. So it will be hard to remove all the suspicious classification or all the attributes that correlate with suspicious classification. But removing those attributes can also be undesirable for other reasons. First of all, they may decrease the accuracy of the algorithm. This could be the case when certain attributes which correlate with suspicious classification are also relevant for educational decision making. For example, the attribute of the classification of a student as an ELL, English language learner, which also correlates with immigrant status. And the second reason is that data regarding suspicious classification can be used for detecting inequality in education. It can also provide us with a deeper understanding of what are the mechanisms that create inequality. And if we remove those suspicious classification, we will not have this information. So, and another technological solution, it involves manipulating the training data set to neutralize embedded biases. Now, this activity, it involves choosing borderline cases concerning protected classes and changing their classification. Even a more direct approach would be to program algorithms to produce equal outcomes. For example, groups that fully reflect population in terms of race, gender, status, class. Now, these two approaches, or these two potential solutions, are problematic from both a legal and a technological perspective and point of view. From a technological perspective, differential treatment would decrease, again, the accuracy of the predictive model. And assuming that ability grouping has some pedagogical justification, that would mean that any decrease could be counter-effective. And the legal challenge is that designing algorithms to correct anything but biases could be easily or reasonably classified as affirmative action, which is also problematic from a legal point of view. Okay. Now, a quite innovative possible technological solution involves developing completely novel ways to group students. Typically, we know that students are grouped according to their perceived abilities based on attainment or tests. But maybe data mining and maybe big data can afford us with other ways, more novel ways, to group students. For example, clustering students based on their learning styles, on their hobby, on their personal characteristics, and maybe other factors that I haven't thought about. Now, these solutions should be, of course, empirically tested, but it does show that maybe we can think out of the box, and instead of grouping students according to their abilities, we can sort them using this technology according to other parameters. Now, to conclude, whether data-driven ability grouping will indeed succeed in delivering justice to all children, it depends on multiple factors, of which legal regulation is only one. Educators and regulators alike must watch the implementation of data-driven ability grouping closely and adjust the design and use it according to the outcomes. Thank you very much.
Thank you all for wonderful presentations. My question, I don't know whether it's a question or a comment, is to Yoni. In my secondary school days, I was part of a group abilities system, and then a new teacher came. The whole thing was dismantled. So I've seen both sides, group activities and all that. But what I'm looking at, from what you raised now, I was thinking, because, recently I've got a very young son. I went to the school, he was about to enter into primary school, and the teacher conducted assessments of everything, and I could see some biases for, I don't know, reasons. But what I noticed was, yes, he was very, deficient in some areas like speech, not of his age, but a very, very high achiever. In some areas, more than secondary school age in terms of achievement in some areas. But what I saw was average in those areas. So when I asked the question, why, average in those areas, the answer was, oh, we didn't have the opportunities. to test him in some of these things. So that brings me to the point now. I think it's now for everyone. When, no matter the system, machine-based system being designed, it has to rely on data. How do we deal with issues of opportunities for data generation? And I can give one example. In terms of credit reference, most people, you get loans, you get facilities because of your credit standing. And the more you get, the more standing you can have. So it means the more opportunities you have, the more you can demonstrate you are great. So the data is generated automatically because you are getting loans and then you pay. There are people who are never given the opportunity, for some reasons, to demonstrate and give that data that can be automatically used by whatever system designed. So how do we deal with such a system? Thank you.
Thank you for the question. I think that it also relates to what Michal is talking about and Doaa, of course. Big data and data mining could be a double-edged sword. On one hand, it can collect and mine a lot of data, okay? Which, of course, it can invade privacy and it can be used against you. On the other end, in education especially, can be used to give more opportunities to those who were deprived of opportunities because we couldn't collect data. For example, if a child couldn't go to be tested, for all kinds of reasons. Yes, the problems with exams, okay. Now we can collect other data and assess you, and then we can maybe personalize learning, or maybe we can assign it to another group, which is based on his characteristics, based on the data, on all those data points that we collected throughout the years in many spheres. Okay, it doesn't have to be attainment or test. It can be also his ability to express himself. Okay, it can be also on his communication abilities. So we can use all this technology to provide more opportunities, subject to the if we know how to do it, of course. And we need this is where we need this legal and of course pedagogical intervention.
Thank you, Michal.
Thank you all for these three wonderful presentations. I have two questions actually to all three of you. I mean, whoever wants to answer. Because one thing that you all pointed to are the limitations in the use of big data that result either from the collection or the analysis or both. So this raises two questions. One is you mostly mentioned regulatory solutions, but I was wondering whether we can think about market solutions and how to combine them with regulatory solutions in order to solve some of the problems that you alluded to. And the second, and this is something that I'm debating in my own work, is where do you draw the line with regard to the use of algorithms and big data? I mean, what is the benchmark that you suggest, assuming that the tools that we have are imperfect? Would you say, I mean, we can always aspire to create better tools, but when would you allow the tools with their imperfections to still be used right now?
Thank you, Professor. So in regard to the first question, I didn't mention that in my talk, but some of the risk assessment used in the criminal justice are developed by the market, developed by private companies. The ones that I looked at were not, and these are the most commonly used in pretrial. One of the biggest problem with the tools developed by the market is the trade secrets protections, and the black box become even blacker, like even more close. And when I talk about transparency, so I support market solutions because the tool, Well, tools that were developed, usually even if the tool is developed by the government, it's usually contracted and outsourced to somebody else. And there's usually not enough knowledge and expertise inside the government. I definitely think that especially for criminal justice, the regulatory solutions and market solutions have to go hand in hand, because otherwise we will end up with more obscurity than we have. The second, what was the second one, sorry?
About assuming that the tools are imperfect.
Oh, yeah. Well, trade-offs should always be made. Where the line is drawn, I think this is the question that we all like trying to answer. It definitely depends on the tool. That's why exactly I said a million times in my talk that all I said is relevant for pretrial. Maybe my next project will be to examine everything for sentencing, and I don't know what the conclusion I will come up then. But I mean, yeah, trade-off should be part of the equations, and that's like policymakers maybe can help us to answer that.
So thank you for the questions. I think with respect to market solutions, I'm afraid that the problem with those solutions is that they often do not work when it comes to the most disadvantaged population, and that is a problem. Because I think market forces themselves often tend to marginalize those who do not have power in the market. And for example, when I discuss the problem of exclusion, it also exists with respect to market opportunities, to advertisement, to services, to financial opportunities that are not always offered by the internet giants, etc., to the poorer people. So I think I'm not sure if trusting the market is enough, but on the other hand, I don't know. I mentioned that and you also discussed the possibility of trying to look for constitutional solutions, etc. But I think maybe some of the solution may be somewhere in between. I think, for example, if government actors or other actors, NGOs, for example, develop some soft norms, some guidelines that could perhaps suggest best practices of how to make the use of big data more inclusive or more equal or more just, then I think such guidelines, even if they are not binding, could have some impact because of market considerations of reputation, of appearance, of equality and justice. So perhaps you're right that the solutions could be not necessarily binding, strict regulation or constitutional solutions.
A combination.
Yeah, a combination.
Yeah.
And where should we stop? Where should we say, okay, no, thank you, if big data is so bad? I don't think we should avoid using big data because of all. I don't think we can. I don't think we should avoid using it because of those pitfalls or disadvantages. But I do think that even being aware of those problems is something very important, because from what I see, many big data advocates often speak about how it is objective and inclusive, and they don't leave much space for questioning the data or the outcomes. So I think we should use big data because it does have many advantages, and I know that some privacy advocates would not like this position. I think it does have many advantages, but and we should not avoid using it, but we should keep critically reflecting about also the weaknesses.
I think that education is a great example to show how market solution did work.
Oh.
So I think that I was saying that I think that the educational sector is a great example to show market solutions. If we go back to 2014, the In Bloom case, if most of you are not familiar with the case, In Bloom was a company. It was funded by the Bill and Melinda Gates Foundation and the Carnegie Mellon. It was funded by, it's a project for $100 million for a learning management system that can mine all the data. By 2014, all the schools in the state of New York, okay, we're talking about 3.5 million students, were using, and all their data was funneled. I was talking about discrimination in my talk, but we can see the market solution for privacy issues. And all the data was funneled into the system. It took about a year or so until parents and privacy advocates raised their voice and said that we're not willing for a private entity, for a private company, especially funded by the chairman of Microsoft, to have this much access and this much control over our data. And that led to the pledge, okay, the Student Privacy Pledge, which was signed by 214 high-tech companies, including Google. Eventually they signed it, and they declared they will not use data for certain uses, they will not pass it to third parties, and there are other amendments inside this declaration and this pledge. So this is market solution, okay? It came bottom up, okay? Eventually, it did lead to some legislative efforts, okay, at state level and federal level, okay. But the origin of these efforts, it came from from the users and passed on to the market, okay. And they took on themselves, they undertook some commitments not to use data in certain ways, and this could also be the case in discrimination. We know that EVAS, for example, one of the companies, one of the ability, it is how is it described? It's a learning management system. It also does group students in math, especially math, and they commit their product is bias free. Okay, this is one company. They committed they don't have biases in their algorithms. It's a bit basic. It's not big data as you would think about big data that absorbs and mines all the data that is available. But they do declare they do not have biases in their system. Maybe it will pass on to other companies and other entities.
Any further questions? Yes, please. Yes.
Yeah, I really like this panel, and I think you guys raised some interesting questions. I was wondering, I think that when we talk about interpretability, which is always comes up in these contexts, I think there's a tendency to underestimate the amount of interpretability you can get out of big data systems, especially if you're not dealing with this trade secret problem, which I think is a problem, and overestimate the degree to which human decisions are actually interpretable. I think the cases where big data is actually helping us in a lot of ways is in cases where it turns out that human decisions are taking into account a lot of factors that people weren't thinking they were before, and these disparities between human decisions and big data systems can often illuminate aspects of the human decisions that weren't being interpreted earlier, and looking at these things can help us understand kind of which pieces of the puzzle are missing comparing different algorithms, looking at the features and how they're going, especially if you can understand the models and architecture and other actually calculating statistics. So I mean, what do you guys say about the opportunity there to actually sort of understand the limits and potential for human rationing, for human decision-making interpretability that these systems give?
I think this is exactly what I try to address in my talk, and well, that's the fear of lack of interpretability. There are technological ways to. There are attempts to open the boxes in some sense, and to, as I say, for example, like distincting between the factors, and the weight that we are giving to each factors. And other technological solutions are like based on limiting the weight that you can give to each factor. So basically making sure that if we have 10 factors, it's not that one is dominating the outcome. I think that there are lots of technological solutions that we can adopt. It depends on the context. So I totally agree with you personally.
So
Just to add that I think that in some areas, the big data might not allow for too much human consideration, at least not in the level of, for example, in the examples that I talk about of collecting health data or disaster data, environmental data, or urban data that is relevant to disaster management. So of course, a human being can be critical of where the data comes from or how it was generated. But basically, sometimes the amounts are so great that you cannot really open the box. You can just assume that the box represents some kind of reality, and then your discretion comes at the point where you have to decide what to do with it. So I think, of course, it depends on the issue and area, how much discretion or interoperability are available.
I will give it a bit. No, I'm just thinking that most users of big data-based products are not sophisticated users. Okay, they don't know how to understand the rationale and the process that goes. Teachers, for example. Okay, once the school district vet a certain system, this is what they're going to use. Okay, they're not going to treat the prediction or whatever decision it makes as a recommendation. They're going to use it eventually as a decision. Okay. So it doesn't really matter whether it is a black box or it's not a black box. This is a system. This is what we're going to use. So understand what's going on. It's not really relevant for the users in this case.
I'm sorry we're out of time, but I'm sure that our speakers will be happy to continue this over coffee. So thank you very much, and join me in thanking our speakers.